This is docket number 996, our motion for order to protect against mistrial. And what we did, Your Honor, is we provided to the court the record of Mr. Jones' press conference on the steps of the courthouse on Friday, including a transcript and a video.
And you provided it to Attorney Pattis as well?
Yes, Your Honor. And Attorney Pattis has made a filing in response, which I have had a chance to review.
You have or have not?
I have, Your Honor. So what we want to bring to the court's attention is Mr. Jones' remarks directed to the jury. There have been already 5 press conferences last week by Mr. Jones on the courthouse steps. 1 on Tuesday, 1 on Wednesday, 2 on Thursday, 1 going into the courthouse before he began to testify, and 1 at the lunch break, and then there was the Friday press conference. And in the Friday press conference, Mr. Jones received a question concerning what he would say to the jury. And his response was, I'm basically barred from being able to talk. If I could talk to the jury, I would say, go research history and understand how dangerous it is, where they'll pick one event of speech and say it's hurtful, and then use that to set a precedent to knock over all the dominoes. Then what we hear on the video, Your Honor, although it's not transcribed, is, and take everybody's free speech away. That is the same nullification argument that Attorney Pattis has been making. Your Honor, in our view, this is very much the domain of the court. Attorney Pattis has argued in his response to our motion that we are seeking a gag order. That's obviously an argument that he wants to make. What we have done is brought the conduct to the court's attention, provided the court with the record. But we understand that it is the court's core function to protect this process, and it's not our function to determine how that might be. So I do have some responses to Attorney Pattis's filing, but I think at this point what I would, if the court would
I'll hear from Attorney Pattis and then you
yes,
can respond.
Thank you.
Attorney Pattis, I did read your filing.
And I won't repeat it. I thought the court addressed these issues Friday, and my recollection is when it was first brought to the court's attention, representations were made that Mr. Jones had made comments about counsel and their families and directed comments to the jury, both of which I think would be deeply disturbing to any court. Upon review of the tape, I think representations were made that there were no threats, that they were comments were ridiculing in character, and that the comments to the jury, that I don't recall what was said. I've reviewed them now, and I think the court's ruling Friday should stand. There is no gag order. No one has sought one. There is no precedent in the United States for prospective limitations on speech under both the state or federal constitution as to a trial participant. I don't think Mr. Jones's comments even reach the jury, which would be a threshold question. And even if they did, they're harmless in the context of this case. He didn't attempt to tamper with the jury. He was asked a question what he would say, and what he said was, go research history. Well, one would presume that would be a good thing to do. It's dangerous when one event is pulled out of context or if one event is used to set precedent to knock over others. And if what Attorney Sterling heard, which I'll credit is there, take free speech away, that's Jones' view. That the court has not sequestered the jury. It has given them admonitions to avoid press coverage. It's repeated those at the end of each day. And it has inquired of the jury each day whether there were notes, I think, at the beginning of the proceedings, and there have been none. So I don't think there's anything for the court to address.
Attorney Sterling?
Your Honor, there is absolutely precedent for issuing orders in this context, and my bet is that the court is already familiar with it, which is, and certainly Attorney Pattis is, Judge Blawey's order in the Fotis Doulos case, in which he issued an order restricting speech of parties. Now, again, we're not arguing as to what the court should do. It's the court's determination as to whether the process is being threatened and as to what remedy would be appropriate. But certainly Judge Blawey's reasoning and order would be potentially helpful to the court in determining how to proceed. And that citation is...
I've read it. I read it at the time it was issued.
Good.
May I respond briefly to that?
Briefly.
Judge Blawey's order was the subject of a public interest appeal.
I also recognize that, and then it was mooted out.
And a good portion of the brief that you read was taken from the Dulos brief. It was mooted out when Mr. Dulos committed suicide. There's been no appellate court or Supreme Court decision. We say the three-part factor of Nebraska press court governs here, and there's not been a preliminary showing that there is a necessity for any.
All right, I don't think it's there's a need to test the appellate orders at this time. I'm going to deny the motion without prejudice. However, it certainly can be renewed if circumstances change, and I might feel differently, frankly, if it comes to my attention there's an issue with the jury, that it's reached the jury. So if that is the case, I will reconsider my ruling.
At the close of court Friday, the court inquired whether I'd be willing to extend the court's concerns about attempting to communicate with jurors. You can infer that that was done.
Any other housekeeping matters before we bring the panel in?
Your Honor, one question and one other matter. The question is, so just so we understand the court's ordinary instructions to the jury will be what happens this morning. In other words, the court isn't going to do anything.
I try to canvass them or mention it every day. I think on Friday I specifically pointed out to them that they might be urged to do independent research by others, and that, you know, that my ruling stands, and I'll say that as I think it's necessary. But if circumstances change, if there are new developments, or if it turns out the jury has been affected, then I'll reconsider.
So the court's instructions will be much the same as they have been on previous
Yes.
days. Then we have one scheduling matter, which is that we would like to schedule a charge conference with the court.
Yes, I'm not sure, have you spoken to each other to figure out, given your witness schedule, when that would be appropriate?
We have, and we think Thursday afternoon could be a good time if that works for the court.
It appears as though the plaintiffs could rest as early as Tuesday of next week, and I'm just repeating a conversation I had with counsel. Mr. Jones, we were unable to reach an agreement about bringing Mr. Jones back this week, so he will be returning to Connecticut and will testify Tuesday and or Wednesday, if at all, given whatever the court rules. And so we expect the case to get to the jury sometime next week. So I believe a charge conference this week would be helpful so that we know what we're shooting at as we prepare our closing arguments.
All right, let me consider it. All right, what else? Anything else?
Nothing here, Your Honor.
Okay.
And Judge, I can't recall whether this took place in the presence of the jury or outside it. Did the court tell the jury Mr. Jones would be back this week? I didn't read.
No, I read the agreed upon comments, and I thought that he said Wednesday or Thursday.
Could you alert the jury that there's been a change in plans, and if he testifies, it'll be next week rather than this week, so that in case they're thinking, you know.
Why don't you talk to each other and give me some language?
Yeah, Your Honor, my recollection is that we weren't that specific, that we said that he would be returning to testify. I think we may have said when called by the defense.
Why don't we look at the transcript? We don't have to mention it now, and see exactly what was said, and then talk to each other and let me know if it needs to be mentioned again. I would like to keep our jury informed, and I surely don't want to misinform them. So if we did say specific dates, I think it might be worth mentioning.
We'll take a look at that.
Okay. Anything else?
Nothing from the defense.
There you go.
Okay. And while Mr. Farrar is getting our panel, I neglected to mention that in accordance with judicial branch policy, only those entities that have been specifically authorized may film or record. And if anyone violates that policy, they can expect their device or devices to be confiscated and to be removed from the courtroom. So please make sure you obey the policy.